In the matter of Inmarsat Global and HMRC Carter.
Yes, Mr. Newey.
The next stage of my submissions concern issue 1.
Yep.
And for the purpose of this stage of the analysis, we assume that IMSO on the 15th of April...
Just one moment, sorry.
On the 15th of April 1999 had deemed property to which Section 78 could potentially apply. And I'm going to start with a sort of generalist observation, which I'll perhaps come back to at the end. We do say, simply as a matter of looking at Section 78, it has the look and feel of a valuation section rather than anything else. And I hope I'll make that good in the course of my brief submissions at the point. What I'm going to do is run through the 4 reasons given by the upper tribunal for finding in favour of HMRC, which were attacked in that form by my learned friend in his skeleton argument. So the first was that Section 78 says nothing express about whether the successor satisfied a belonging condition. Now, what my learned friend seeks to do is to turn this around completely, and he says that if ownership by the successor was important, it would have been spelt out by Section 78. And he particularly relies on Section 77 to make that point. Now, we say his argument based on Section 77(4) proves too much, in a sense. If one turns to that, it's Authorities Bundle 1, tab 9, at page 109. And you'll recall my friend explained that there were 2 stages to this legislation as contained in Section 77. So a pre-1988 version and a post-1988 version. And we're looking at the post-1988 version. And you see there in subsection 4, Roman 1, immediately before the time when the succession took place, belonged to the predecessor, and then Roman 2, immediately after that time, belonged to the successor. So we say there that the simple answer to what one finds is that there are different drafting hands at work. We know that the equivalent of Section 78 was found in the 1945 Act at Section 60, and that's in the bundle, whereas this we know was drafted in or around the late 1980s and certainly implemented with effect from that period. And so my friend has already accepted that Section 78, albeit it doesn't present any express words saying that predecessor should own, nevertheless it has that effect. So we say here the draftsman has chosen to set out those 2 features, but that really doesn't take us any further in the interpretation of Section 78. The bigger point, perhaps, to refer to in relation to this, though, is my friend's proposition that the inevitable corollary of property being deemed to be sold is that it is owned by the purchaser. Now, you've already had my brief submissions yesterday in relation to Crossman and Lionel. I don't propose to go back to those again. But we suggest that this is a bold proposition for my friend to make, and simply not made out on the drafting. The upper tribunal correctly identified that it was not an inevitable consequence of the drafting. It's perfectly consistent with there being an assumption that Section 78 will only apply where the successor actually owns. And again, that makes sense once one correctly perceives, as we say it, that Section 78 is essentially performing a valuation function. It's a valuation mechanism, to use the word that I used yesterday, in respect to property which passes without sale. That can, to a degree, be illustrated from the wording of Section 78 itself when one looks to 78.2. So if you've still got that bundle open, page 110, And what you will have seen is that subsection 2 is, if you like, a subset of subsection 1. One sees that from the words found just after the indented A and B. So where a person succeeds to a trade as beneficiary, etc., the reference in subsection 1 shall, etc. And what one sees going back to an earlier part of subsection 2 is the words then in relation to any machinery or plant which passes to him together with the trade. So we say there that's simply drafted in those terms almost in passing because it's recognised that property passes. And that is clear from the drafting as well as independent of, stated in advance of, the hypothetical sale mechanism, because that's referred to later on in subsection 2. Again, after the indent, the reference in subsection 1 to the price which the machinery or plant would have fetched if sold in the open market shall, in relation to the succession and any previous succession, be deemed to be a reference to that price, or then there's adjustment available. And again, to emphasise the point about this being a subset of 1, this of course only applies in relation to sorry, I apologise. That was a bad point I was going to make. It was by reference to another matter. So we say on the first reason, this is not one which should cause this court to differ with the upper tribunal. The second reason that my friend challenged in his skeleton was the comment made by the upper tribunal that in deeming the transaction to be a sale and specifying net proceeds, Section 78 appeared to focus on the predecessor. And his assertion is that in no circumstances would a different treatment be spelled out of Section 78. Now, in a sense, this involves a degree of mental gymnastics, because the reason why it doesn't spell out any different conclusion is because they've gone to the trouble in Section 78 of making sure that one reaches the same conclusion. So we say there is a reason for that, and it's the one identified by the upper tribunal, that if you simply stopped at deeming there to be a sale, the consequence in Section 26 is that under 26(1)(a), one gets to net proceeds of sale, at least as a starting point. Now, that obviously raises, for the reference, that's page 48 within that same tab. We perhaps have that up. So reading to the words in 26(1) at the bottom of page 48. In A, unless paragraph B applies, if that event is the sale, etc., equals the net proceeds to the person in question of the sale. And obviously that makes enormous sense in the case of an actual sale. So and the net proceeds may be substantially different to the proceeds of a hypothetical sale, which is simply at open market value. So for instance, one of the cases in the bundle, the concern, and it's a matter of Tizer, which I don't think I need to turn up, was about the very substantial costs associated with selling property under the will of a member of the Oppenheimer family. And where one's got an actual sale, therefore the concept works. What Section 78 does is, having recognised that we want sale to be what we're looking at, is then say, well, albeit it's a sale we've deemed, we're going to just deem an open market value to make things clear. Now, we say that's enough of itself for a reason for the drafting as it's put by the draftsperson. So even if it is a duplication, we say there's no difficulty this court should find with that. We also say that my friend attacks rather too vigorously to be appropriate in the circumstances. I mean, I'm not saying he's done something unprofessional, but the suggestion that this was an at-a-glance summary, and he says, well, this isn't a drafting technique found at this period. I suggest that reads too much into what the upper tribunal were trying to say. We respectfully say they're simply using this as an opportunity to clarify, and why shouldn't they have done in this particular context? Because absent that clarification, there is this potential question, certainly in the minds of creative members of the legal community, as to whether there is something other than an open market value to be derived from the sale.
Can I just try to confuse myself and probably everyone else for a moment? So you say that once you've imported the idea of a sale in section 78, from the predecessor's point of view, you need to explain that it's open market value, not net proceeds of sale.
Certainly that's an element of it, but it's a legislative choice that goes beyond simply explaining it. It does set what the price is for both predecessor and successor. We're not denying it creates a role for the successor, but we simply say that it's definitely got a role as regards the predecessor, which is more than purely linguistic.
But from the predecessor's point of view, if it had merely said sale, then you would have been into a choice between net proceeds and...
It would potentially have raised a question, and that, with respect, is sufficient, we would say, for it to be perfectly explicable why a draftsperson would have chosen the drafting technique involved.
And just taking it a stage further, supposing you hadn't had section 78 at all, from the point of view of the predecessor, nothing would have been needed.
And there would have been no confusion to alleviate, for the reasons my friend gave, because if the predecessor had discontinued his trade, then one would simply have applied section 26.
And then you would have ended up at open market value.
Yes.
So in that sense, section 78 has to be there for the successor.
We're not denying it has a role for the successor.
Yes. So if you didn't have section 78 at all, in circumstances where the successor acquired property but without a sale, how would you then value?
I think that's one of those fundamental questions that goes back to why they put it in the legislation in the first place.
Yes.
There was a concern that if one didn't, there would be a need for such a mechanism, because succession does present obvious opportunities for manipulating things. Again, not suggesting that's what the average taxpayer would do, but of course the draftsperson is concerned about what might happen.
Yes, I mean, what could the position have been from the point of view of the successor in circumstances where he's acquired the property from the predecessor but without a sale?
Well, let's imagine he simply acquired it in some part of some larger arrangement that isn't a sale at a value which isn't an appropriate value. I'm speculating here, but again, the draftsperson is trying to deal with situations that he or she can't immediately envisage, but he recognises that tax legislation is always attracted to creative analysis, if I can put it that way.
Yes, I see.
The third reason given by the upper tribunal, which is challenged by my learned friend, is the words at the end, but no first-year allowances shall be granted to the successor. And the upper tribunal said it sheds no significant light that those words are there, because they arise on HMRC's interpretation in any event. And my friend says, well, it does shed light, because it emphasises that section 78 makes writing down allowances available. And we understand by his submission that what he's saying is not just makes them available, but can make them available in circumstances where they weren't otherwise available. Because, of course, it's key to his case that he gets the allowances by virtue of the operation of the mechanism in section 78. He hasn't suggested an alternative route. Now, we do say that as regards the successor, it must be right that it envisages that the successor successor is able to claim with writing down allowances, and it's able to claim them on the basis of the value set as
Sorry, I don't know about the transcriber, but I'm having a little difficulty hearing you.
I
Speak up a
apologise.
little. It's not a question of the mic. It's just
it's
speaking
the volume of my speaking voice. I will
It doesn't just a notch more.
lift it a notch, and if I overdo it, my
Yes.
boss will tell me.
Thank you.
So, as in the discussion with my Lord Justice Newey, those writing down allowances are made available by reference to a particular sum set in accordance with the mechanism. But we say that that's entirely sensible where you are assuming a transfer of actual property. It doesn't need to do any further work in terms of deeming people to get writing down allowances who wouldn't have got them at all, namely those who have deemed property along the lines of my friend's argument. Now, we, in terms of other arguments that were put by my friend, we don't have any difficulty really with a number of the points that he makes. First, we accept that sold is given an extended meaning by section 150 subsection 4. Similarly, we accept that where a trader starts a trade in consequence of a gift, it makes no difference because of the role of section 81.1. I think we described in our skeleton that there was an overlap. It's not entirely clear which takes precedence, but perhaps for this tribunal that makes no difference, and certainly is not one that you need to venture into on our submission. We also recognise my friend's example in relation to intra-group transfers, which was section 343 of ICTA, which in terms disapplies section 78 because it says that the Corporation Tax Act shall have effect subject to. So that by implication clearly takes precedence. And therefore we do accept what my friend says, that section 78 is likely to apply in relatively limited circumstances. But we draw a different conclusion from that. And we certainly disagree with the forensic suggestion that it's impossible to believe that section 78 should apply in such a narrow way. There are two particular areas I was going to give as examples of where it might have a role to operate. The first, and I've shown you already, is in relation to successions on death. That's at section 78.2, because this only operates the modified treatment if the beneficiary by notice to the inspector so elects, i.e. if you don't elect, section 78.1 has a role. And secondly, there was the...
Can I just understand that? So sorry, section 78.2 only requires election, doesn't it? I haven't noticed. Yes, I see. So elective, so elect. So what's the difference between section 78.1 and section 78.2?
Because in section 78.2, if there's a difference between the open market value and
the excessive qualifying expenditure.
Yes, then basically it's beneficial to make the election. But if you're not in that territory, there's no point in making the election. The election will give you either the benefit of one or the more generous treatment in 2, but 2 still operates to work in the same way as subsection 1.
I mean, I suppose it doesn't necessarily provide much of a reason for 78.1. You could just have 78.2.
The way it's drafted clearly works on the basis that section 78.1 is the fons, it's the fount of things, and has a wider role. One's got to be careful, obviously. I'm not trying to go into the archaeology, and indeed I haven't in preparation today, but that's a provision which has been there for many, many years as well. And it's not necessarily the case that in its original form it was perhaps as limited as it may now appear.
Well, you say you're not going to go into the archaeology. In some ways I welcome that. But I do wonder whether what we have here is I think this came out from yesterday, a provision which in its original form had a wider scope, whose scope has then been reduced by subsequent legislative changes, and perhaps a draftsman in 1990 could have felt you don't need it anymore anyway because everything in it is important is covered, but covered elsewhere. But given this is a consolidation statute and given you don't want to change, you just leave it where it is, acknowledging that its scope is much more limited than it was in 1945. Please do look that gift horse in the mouth if it's wrong, but
it's certainly a possibility. I'm careful about putting a positive case on that basis because one's got to accept the Act as it is. But it is clearly the fact that if there's a section which has worked in the past, you're not absolutely sure it's gone wrong. You're not sure it's going to be of great importance going forward. What are you going to do as the draftsperson, as the parliamentary draftsman, trying to work out what to do? There is a good chance that you will simply leave it as is, and certainly one of the challenges my friend and I both face in this is that, albeit wording very close to Section 78 has been in place since 1945, this particular question has not arisen. Now, the forensic point I can make is, well, if my friend's point was good, somebody would have thought of it by now. But again, I don't put that front and centre of my submissions. The arguments yesterday particularly focused on the clear cutting back of, as it happened, Section 61(4), and that was the consequence of the Stokes decision, which led to a result which the Court of Appeal said firmly was one they weren't comfortable with, and within 4 or 5 months of that decision coming out in the middle of 1984, I think announcements were made that the fixtures regime would be brought in, and that was then brought in by FA 1985. And one can see it's in terms of the Melliwish decision that both parties say the fixtures regime was to fix the problem in Stokes, and that's changed the world in effect. The court agreed because the fixtures code was self-standing and exclusive.
Right, we're getting off the point with respect to that. That's Section 61.
Yes,
but you're tactfully suggesting that may be more what I had in mind when saying we went into this yesterday.
It may be that was where the particular debate was, my lord, yesterday, rather than Section 78.
Yes. But could a similar argument be running? The answer is you're not positively advancing a similar argument.
I'm not
positively
advancing one, not least because there isn't a similar watershed event such as the Stokes decision in relation to anything that's happened in 78. It's clear that the context of the section has changed enormously over the years, but I haven't, for instance, tried to do, I'm not sure, as your lordship says, that you'd find it of great assistance for me to spend much time on it, how the predecessor of 78 fitted in the 1945 Act, from which obviously...
Okay, well, if you haven't done it, I'm quite sure that's a sensible exercise of your professional judgment, but I'm just... When one's presented with a section that one of the arguments says, if it doesn't mean what I think it says it means, as Mr. Prosser, it's hard to see what his point is, to which one legitimate answer would be, well, it may not have much point, but that's just an accident of history that sometimes happens.
Well, Lord, I would respectfully adopt that as a way of expressing it, but I wouldn't go to the further step of saying it's been cut down in certain ways, but was left there.
I see. Okay. But so just to finish on that point, well, I think we were told the 1990 Act was a consolidating act. Was it a consolidating act in the strict sense? It wasn't intended to change the law at all.
There were very minor changes, but I think both my friend and I have worked on the basis it was in the strict sense a consolidating act. And there was debate about this in front of the FTT in particular. So we've approached matters on the basis that Farrell and Alexander applies, and therefore the 1990 Act isn't to be interpreted by close analysis of what similar provisions were in previous legislation. So we adopt that caution approach, though recognising that inevitably, for instance, looking at old cases, the court not only will want to look at, but will be assisted by the decisions of previous courts in relation to the earlier legislation.
Thank you. I'm sorry, my
No,
lord at the point.
Just before leaving this, I can see if we go to tab 6, the 1968 Act, section 48, looks pretty similar to sections 78, 1 and 2. Well, it's obviously not the same, but it seems to have a similar structure.
Well, again, I can show you if you want to have similar structure. Again, this is just for viewing, really. It's page 11 in the bundle.
So that's the 45 Act.
That's the 45 Act.
And that doesn't seem to have had an equivalent to 78.2, but that may have been found somewhere else, I don't know.
And tell us that came in later.
Is that right?
Yes, and I can see that it might be a response at some stage, but this is pure speculation. It might have been a response at some stage to a beneficiary complaining that the way it worked was unfair on him effectively as a volunteer.
So is that what came in did that come in 68, or is there an intermediate stage?
I can't give you an immediate answer on that, I'm afraid.
Yeah.
If it's of assistance to your lordship, we can look it up and send something to you after the hearing. The other example that we gave was the trade devolving on a trustee in bankruptcy. I'm not sure how much more time I need to spend on this because it was addressed briefly yesterday. You saw the clip. We say it is the case that trustees in bankruptcy, not always, but occasionally do carry on trades. And respectfully disagreeing with my friend, if the trustee, when carrying on the trade, chooses to appoint as his agent the bankrupt to do certain things in order that the creditors get better paid, is the trustee carrying on what was the pre-bankruptcy trade, not the bankrupt trading, which of course would not obviously be the intention in those circumstances. But
The bankrupt in that case is essentially a manager on behalf of the trustee,
yes,
is that right?
My lord, we would adopt that. Yes. And there are obvious practical reasons. You can imagine that where well, my lord, you have the point. So standing back, we do say on one level, we don't appear far apart, my friend and I, but the conclusions drawn from the relatively narrow ambit of Section 78, we say point in our direction rather than my friend's argument, which is that, well, it must be doing something else. We say again, just take it at its face, and it appears to be providing valuation in certain circumstances where property is passed. So the fourth reason given by the upper tribunal, which my friend is challenging, is the reason that if Section 78(1) were intended to establish a deemed belonging, it might have been expected to deal with matters such as what happens when it comes to an end. And the comparison was drawn with what's been called the tailpiece of Section 61(4), which says what happens at the end of the lease. Inmarsat says that none of the difficulties identified by the upper tribunal arise, and they, certainly in their written submissions, say, well, the solution is to imply a deeming that the successor continues to own the property for so long as he continues to use it for the purpose of the trade. And in his oral submissions, I got the sense my friend had moved somewhat from that to simply to focusing in terms of, well, you can look at what actually happens in Section 24 terms, and you can see, well, possession might end, etc. And that's sufficient. So there's no need for the draftsman to do anything. Well, we do make the point that if one is dealing with deemed property, the obvious thing to do is at least to try and say something as to what happens in those circumstances, because questions inevitably arise. The fact that there might be, as my friend suggests in relation to the contributions code, some potential difficulties that haven't been worked through in the legislation there doesn't make that a bad point. So for example, in relation to possession, so possession comes to an end. Well, is possession as a lessee what is to be in mind? Is it, because of course the deeming here makes the lessee possessor, is it, or possession by the owner? Well, as I say, on my friend's arguments, he simply said, well, it would just makes him the owner, so that's fine. But the uncertainty it creates by simply leaving this deeming there, we say isn't consistent with a sensible interpretation of section.
Isn't consistent
with a sensible interpretation of section 78. If it's going to do something as we would say radical as creating a deemed ownership, where the legislation elsewhere seeks to say what the consequences are, we would say it's an obvious thing for the draftsperson to have done, to have sorted things out, and we focus in particular, and I'll stress this, on the question of market value if there is to be a disposal event in due course. Now, my friend says, briefly in a skeleton argument, well, it's straightforward. It's plainly the market value of the property, and he talks about that being based on X% co-ownership. But otherwise, valuation issues are parked, and we're not to get into those now. Now, for the purpose, at least at a high level of identifying what one should do in his proposed scenario, it is worth addressing the question, well, how is that to work? You're looking at deemed ownership of satellites, but based on launch costs, which were simply expended in the past. There is no actual ownership of any part of the satellite in the real world. The lessor sells the satellite at the stage that suits the owner of the satellite, and it's entitled 100% of the proceeds. That's the essence of what the documentation seeks to achieve in these circumstances, to ensure that the lessor is entitled to relief. So those sort of questions, we say that the silence on what is to happen in relation to this valuation in this world of co-ownership or deemed multiple ownership is a significant feature. And this court can take that into account without trespassing on the parked issues, if I can call them that, in relation to valuation, which only arises if my friend is successful in principle on his arguments. So
Can I just sort of understand that? So we suppose that Mr. Prosser is right about section 61.4, and so at the stage where the novation has happened, Abbey National continues to be entitled to writing down allowances as lessor, but Inmarsat becomes entitled to writing down allowances in respect of its expenditure on the launch costs. Then we assume that the property ceases to be used for the purposes of trade or it's sold. As a straight sale won't do, will it? Because if Abbey National simply sold, Inmarsat would still be entitled to writing down allowances, presumably.
well, the question that the Lordship poses is one of the challenges we face. I mean, what does happen? And if you simply sell the property, well, you've got the market value for satellites, but why should any proportion of that be attributable to
Launch costs. Can I just go back a stage in terms of disposals? So you've got the position where the satellites are in Inmarsat's hands. Suppose Abbey National sells. That's a disposal for Abbey National purposes.
My friend would say it's not a disposal for him, I think, because he's continuing to use it for the
No, I follow that, but it is a disposal for Abbey National purposes.
if they sell the satellites, yes.
And they bring into account what they sell the satellites for.
Yes, if that's a market value, yes.
and the successor then takes over the writing down allowances.
Well, the successor then will have its own cost for buying satellites.
If it's a sale, obviously that's true. Yes, yeah, I follow. But the fact that the satellites have been sold won't represent a disposal for Inmarsat purposes on Mr. Prosser's case.
Not as we understand it.
So now we assume that the satellites simply cease to be used for the purposes of a trade. Maybe a bit unlikely. Well, I don't know, they become useless. So therefore, they cease to be used for the purposes of a trade. How does that work? Is Abbey National still entitled to writing down allowances on the basis that, so to speak, they're still being used for the purposes of its trade of letting?
So, I suppose that's right. Theoretically, if Inmarsat ceases to use them, but Abbey National wants to lease them to somebody else.
Suppose they don't even want to lease them to someone else, they just want to hold Inmarsat to their bargain. Inmarsat has no continuing use for them, they're now outdated. But Abbey National can it say, well, it's still using the...
well, if they're available for use, it perhaps can. I'm conscious I'm straying into territory where I should double check, because this is an area which is of immense complexity, as your lordship knows. Nobody's metaphorically tugging my gown so far, but I think one thing that's
yes.
important. Sorry, my lord.
Well, I agree. Available for use is a really tricky phrase in this context. In one sense, they're suppose they're not working. That would probably, quite often look at the terms of the lease. That would probably be a reason where you could terminate the lease. But supposing they're working fine, but they're just obsolete. Elon Musk's ones work better, and everyone uses them. Probably an ignorant remark, but somebody else's, they're obsolete commercially. Are they then available for use?
I will
Suppose
say I would prefer to have detailed instructions on what are difficult speculations, which are very particular facts.
You'd think Abbey National would be upset. I mean, this is probably provided for somewhere in the contract, but you'd think Abbey National would be upset if they lost the benefit of the writing down allowances while still being paid the same amount by Inmarsat.
Yes, I think it's difficult to hypothesize a situation where Inmarsat is still paying them, but for some reason they're not.
I don't know, if they're just obsolete and it's an equipment lease, doesn't Inmarsat have to go on paying them?
In which case it's still being used for the purpose of the trade.
Of Abbey National's trade?
For Abbey National's trade, I would suggest.
Yes,
but again, I would defer to those behind me who specialise in these things if one got into...
And can there be an...
like that.
I mean, this is maybe the same question put differently. Can there be an occasion when there's a disposal for both Abbey National purposes and Inmarsat purposes at the same time?
Well, on my friend's... Sorry? Yes, but on my friend's suggestion, let's imagine they're destroyed.
Yes, I see. Okay, so we assume they're destroyed, which is, I suppose, not that unlikely.
I think the most likely time to be destroyed is at launch, in fact. I think once they've been launched, they usually do quite well.
Yes. I don't know whether there'd then be a question as to whether the lease period had started. Anyway, so we assume destruction. At that point, there's disposal for both purposes. And you say, well, the satellites then have to be, I don't know what to... there's no value to bring into account, I suppose.
Yes. Well, no. My friend suggests, well, what if both trades are discontinued at the same time? Not necessary for the same purpose, but both trades are discontinued at the same time.
And, I mean, maybe that's, I don't know.
Why does that make the question different?
It would mean that there would be value to be had, potentially, depending on what market there was, open market value for the satellites once the trades have been discontinued.
So at that point, you would have to worry about what had to be brought into account by Abinational and by Inmarsat.
Well, we've approached this on the basis that my friend's argument doesn't turn on what happens with Abinational.
No, you say it's just Inmarsat. If they, if there's a disposal for their purposes, you have to work out what you bring into account for their purposes.
That's what my friend says. But I mean, to use your lordship's example, well, what if there happens to be a disposal for both Abinational's purposes and Inmarsat's purposes, on my friend's argument, at the same time? Well, valuing satellites, I've no idea, but might be quite challenging. But for the purposes of Abinational, you can say, well, you're valuing 100% interest in a satellite that's in orbit. Assuming there's a market for that, then you can do something about it. If you're trying to value the satellites for the purposes of my friend's argument, and he accepts this, it would clearly be absurd to say that they're to be entitled to the full value that the lessor can get on its market value hypothetical sale. So he looks to find a way to limit that, and he's suggested the X%. But why should it be that? You know, why shouldn't it be the market value of launch costs, for instance? Because at least that's tied to the money that was put in the first place. Well, the obvious answer is there's no value to launch costs because they've just been expended. There's nothing in addition to the value of the satellite which Abinational gets. But there's no immediate answer as to how you capture what he's trying to say is what is to be valued, namely the benefit of the expense incurred by IMSO in the first place. So
that's why, it's, as a non-tax lawyer, as you will have detected, I've been slightly puzzled why the launch costs can't go to capital account at all, but until they do. So, but as you say, then, not what a non-tax lawyer would regard as capital.
It's been an agreed feature of this case throughout, and I've certainly not independently looked at it. I'd simply adopt what my friend says. That is simply what the treatment is.
So
but with perhaps your lordship's same.
No, I mean, well, I'm very likely to be completely wrong, but it's when you were talking about market value, you can't have a market value of launch costs because they're just one-off expenditure. You don't get anything for them. Well, it's a capital asset.
And certainly, to adopt what your lordship says, as a non-accountant myself, I could easily see why. Well, it might have been said that this could have been just money that was expended once and for all on income account, but it wasn't argued. I'm not proposing it, but I could have seen if somebody had said to me.
There we are, but I'm certainly not suggesting we should decide the case on that basis, but I'm just teasing out the difficulties that you're saying about how you value launch costs if you regard them as an item of capital expenditure.
Well we've I don't want to unnecessarily repeat the points that we've made, but we do say there are problems there because it goes beyond simply, for instance, hypothesizing a sale of a real item of property, which is what one does all the time under the Taxation of Chargeable Gains Act, for instance, or under the ordinary mechanism that's given in section 26. What you've got to do here is value a particular bit of property, but in circumstances where you've then got to do something else as well to adjust the value you get for that property because it's owned by somebody else and you didn't own the whole of that property. It presents fundamental conceptual challenges to grapple with. And I accept that to a large degree they're for another day, but that there is a point in terms of the interpretation of the legislation that makes it something that we do need to touch on, at least in this hearing.
I mean, with this arrangement, everybody would know how much Abbey National had spent. But that wouldn't necessarily be true with the leasing arrangement.
That would turn on the facts, my lord.
Yes.
We do know here. I don't deny it. We do know what the launch costs were.
But what I mean is,
we know what Abbey
suppose,
National spent as well.
suppose Inmarsat, suppose an equivalent of Inmarsat makes a disposal, and you then have to do a percentage calculation. You need to know what the lessor has spent as well, don't you?
Yes, on my friend's argument. Yes. Those were the 4 points that my friend challenged in his skeleton argument, as found in the Upper Tribunal's decision. There were a couple of extra points that we picked up in our skeleton, which I can, which they mentioned, which were separate to those. First, there was the question of policy. There's a very small point. My friend's skeleton argument says that the Upper Tribunal said it made sense in policy terms to provide in the way that he suggested Section 78 should be interpreted. The precise words used by the Upper Tribunal were, "We quite acknowledge Inmarsat's submission that it might have made sense." We said it doesn't go quite so far. That's a relatively minor point. The point of more importance is that in saying that, the Upper Tribunal was both neutral, made no final determination, and moreover, it wasn't suggesting that the conclusion they reached themselves made no policy sense. They could see a policy sense in Section 78 doing what it did as they found and as HMRC submitted. And to go back to the submission I made yesterday afternoon, Parliament had a legislative choice as to what to do. It's made that choice, and we say it's made it by reference to the actual passage of actual property. So we do say, therefore, that the reference to policy doesn't assist my friend. It doesn't advance his argument any further. Then there was a point about wholly and exclusively in the absence of those words. I think the point on this is a very short one. It's simply that it reinforces the conclusion that Section 78 isn't doing as much as my friend suggests, because it's the sort of thing that at the very least the draftsperson might have considered saying something about if it was the case that Section 78 was to apply to deemed property as well. Now, there was a final point, which is our point, which I think is a useful springboard into the slightly different area of issue 3C, which is a kind of limbo, as you recall. That's the tailpiece. What's the effect of the tailpiece in Section 61(4)? And we made this in paragraph 23 of our skeleton. It's very brief. That even if there is a deemed ownership of the satellites pursuant to Section 61(4), we say that there's no reason to take that deeming so far as to use it in Section 78 to be a deemed ownership, which can be the basis of a deemed ownership by a successor. So Section 61(4) and Section 78 don't need to be yoked together that way. It's not a necessary consequence of Section 61(4). Now, as I say, I've used that as a springboard. Issue 3C, it's an unusual thing to have before the court, but you'll recall that the Upper Tribunal was of the view that the tailpiece did not prevent IMSO as predecessor having deemed property for the purpose of Section 78, because it looked at the moment in time before the succession took place. And that was accepted by HMRC below, and I think it may be because of that acceptance that it had a rather downplayed role in the Upper Tribunal's decision. And as a result, they made no determination on the point, the consequence of which is that, at least as it appears to us, the FTT's decision in relation to the tailpiece stands, namely that the tailpiece assumes that the property actually belongs to the lessor after determination, and also that novation was a determination of the lease within the meaning of section 61(4), and that the point one's left with is that the FTT concluded that that was difficult to square with the operation of section 78 as proposed by my friend, because in the section 61(4) world, the lease is over and the deeming, as a matter of fact, from the point of the novation has come to an end. The lessor simply owns. Now, my friend's skeleton goes so far as to say that we're arguing that section 78 is prevented from applying by section 61(4). Now, with respect to my friend, it's not quite how we put it. We put it as being, and perhaps this is the best way to characterise it, is section 61(4) consistent with Inmarsat's argument? Are you recognising that section 78, my friend looks back to the moment before novation, but taking a wider view and saying, well, if section 61(4) says the deemed ownership comes to the end when the lease comes to an end, how does that sit? Is that a sensible set of provisions to have together in the legislation, the section 61(4) reversion to the lessor of the very deemed ownership my friend relies on, and yet my friend continuing to be able to rely on it for the purpose of section 78 to get the deemed ownership that he needs through that. So
sorry, can I just go real back on that one a bit? So the problem would be that is the inconsistency, the conceptual inconsistency between the consequence of section 61(4) tailpiece, saying it all comes to an end and the interest reverts back up to the lessor. That's what section 61(4) would indicate. When you put that alongside the argument on section 78 that says the deeming carries on and the belonging is in Inmarsat, the successor. Those two
lady,
just don't live alongside each other.
Yes, my lady, yes.
I'm not sure I have quite got my head around this. I mean, a view might have been, look, section 61(4) says that when there's a novation, the lease comes to an end, and that means that the property is then treated as the lessor's, and section 78 simply can't apply because the premise for section 78 applying is that the property is treated as the lessee's, and it can't be because section 61(4) says that's no longer the case. But as I understand it, you're not avowing that proposition. So if you're not avowing that proposition, why does the tailpiece have any bearing on this?
Because of the uncomfortable sitting, that if, and there's a risk I'll repeat myself, so I apologise, if it's the case that for the purpose of section 61(4) you can see that the lease has come to an end, the property is now the lessor's, the provisions are meant to operate to ensure that matters are dealt with fairly between the lessor and the lessee at the end of the termination of the lease. But nevertheless, that looking as though it's due just to reach a final conclusion to their relationship, but nevertheless, elsewhere in the code, the deemed ownership not only carries on for the lessee, but also the lessee's successor under the deemed sale. As I say, it's not quite going so far as to say it can't happen, and the reason we accepted that below is that there's two different drafting techniques at work in these two sections. So in section 78, you're looking back to the moment before the successor concession. And that's why we perhaps go 90% of the way rather than 100% of the way in the submissions made in the upper tribunal and here. But that doesn't deprive the submission, we respectfully say, of some force, namely that it conceptually they don't seem to sit well as part of a coherent thinking. I'm not sure if that answers your lordship's concern. And it may be helpful at this point to have a quick look at Stokes, and you recall that Stokes essentially is the case which said that section 61(4) in its original form missed fire, to use a form of words used in previous authorities. Stokes is at Authorities Bundle 2, tab 43. And the debate, if I can put it very briefly, in Stokes was whether somebody who was a lessee could claim allowances, and the answer was, well, that they can't, because when you talk about belonging, you're looking at absolute ownership, and that's an end of it. But if you look at letters C to D on page internal page 770, bundle page 619, it was clear to the court how it was meant to work. They say, this is Lord Justice Fox, I might add, the draftsman had very much in mind the difference between the position of a lessee and an absolute owner. Thus, in the case of a lease, special provision is necessary to determine how a balancing adjustment is to be made under section 44(5). It's necessary because at the end of the term, the machinery and plant will revert to the lessor, and it is he and not the lessee who will realise the disposal value. Accordingly, provision needs to be made to bring it into account. The final provision of section 46(2) does that, and that is the tailpiece of section 61(4). So you know, the court was saying in terms, and it wasn't disputed, that's what's happening here. That's what one's trying to capture with the tailpiece, is just to make that final adjustment so that the allowances, the balancing charges, are in the right place at the end of the relationship, which is the end of the deeming. I say the end of the deeming. I need to be a little bit cautious because it could, of course, be the case that there are still allowances to be gained within the pool, because unless the trade has ceased, the pool may still contain certain amounts which need to be taken into account in the ongoing annual calculations of allowances.
Sorry, just confusing myself again. I mean, this makes sense when you're talking about things that have accrued to the realty. When the lease comes to an end, the landlord gets the property, the landlord is going to get the whole of the disposal value in due course. But under the legislation as it now is, that's not the case. We're only dealing with things that aren't part of the realty.
Well, my Lord, that leads me to stray into an area I was going to come to in a little bit more detail.
In that
later.
case, come to it later.
But we said there is a shadow left by how the Act was originally intended to work, and when one looks at the wording of the subsection, that's not to be wholly left out of account, if I can put it that way. But I'll develop that further, if I may, slightly later on. I was going to deal briefly with the question of determination, the word that's used in section 61(4). My friend didn't address the Sargison case in oral submissions, so you have our oral submission, our written submissions on that, so I needn't deal with that further. But just on some general points of principle, it's clearly not a defined term in the legislation. It terms to various authorities, including, as a textbook, Chitty, Green King. But I was just going to look briefly at the decision of Mr. Justice Millett in Collins and Adie's, which is at tab 21 in First Authorities Bundle. And within that, page 212 in bundle numbering. And simply ask you to read the short passage with the sidebar.
Yes.
And we say the court can, with respect, the court can reasonably conclude that the draftsperson was fully aware of so basic a provision of the law when they drafted the legislation in the form they did, and the determination was intended to capture all forms of determination as identified. Moreover, and we've made this particular reference in our skeleton, but I'll show you it as well. In the supplemental bundle, at divider 17, and this is within that 243, page 243. This was within the master transition agreement, which was signed a few months before the actual transition date. But one of the conditions precedent you'll see is 3.1c, delivery to the company of a written agreement of novation, etc., etc. And the last few lines in the finance letters that are reduced to writing, effective on completion and upon becoming effective, cancel and supersede the finance leases. So that's as much as we wanted to say about the tailpiece. It's in this kind of limbo position because it wasn't something the upper tribunal decided, but it is important to address, and both my friend and I, Master have addressed it. I move on to...
just before we leave the tailpiece, can I just get it in the right space? It's necessary for the appellant to win on the tailpiece to get home, isn't it? So the upper tribunal had decided against the appellant on section 78 and therefore parked the tailpiece.
My lady, yes.
They didn't need to go there. But if we were not with you on section 78, but we were with Mr. Prosser, in principle, on the sort of general concept of section 78, then we would need to tackle the tailpiece, wouldn't we?
I think my friend certainly needs to attack the decision of the FTT on the tailpiece. And he's nodding at me.
Doesn't look very enthusiastic about it, but I think that's where it fits.
Yes, certainly that's where we apprehend the position is.
Can we just see exactly what the FTT did say about the tailpiece?
Yes, sorry, I should have given you the reference earlier. It is... It's divider 11 of the core bundle, pages 158 to 159.
Just give me a moment, just to quickly reread that page. almost exactly how, but that is how you put it, isn't it?
My lord,
You've
yes.
got the nuances exactly as you were putting them to us.
Yes, my lord, and just to put it in a broader context, what you'll recall is that Judge Poole said he decided against Inmarsat on section 78, but in case I'm wrong on that, then dealt with the other matters. So strictly it could be said to be obiter unless his section 78 finding is overturned, but those technicalities perhaps ought to
Well,
be.
it doesn't matter whether it's obvious. The question is whether it's right.
Yes.
He's brought it back in or brought it in earlier in paragraph 59, and I suppose that's where it would belong for this purpose.
Well, that's why I've dealt with it in the way I have here,
Yes.
rather than putting it after 3b, which I'm coming to later.
So in that sense, it would be artificial to suppose that we sided with Mr. Prosser on section 78 and then considered the tailpiece. The tailpiece would feed into our assessment of section 78.
Yes, to use, perhaps an overused word, a holistic view would suggest it's part of the consideration of issue 1.
But the UT didn't deal with it because they didn't feel they needed to.
They didn't feel they needed to. It could be said when you look at their wording, they expressed themselves in slightly surer form as to 78, and they deliberately took the other issues shorter in consequence.
Yeah.
So I was going to move next to the potentially challenging area of the purpose of section 61.4 on the basis of the implied invitation, if you like, from the upper tribunal to at least have a go at explaining what the purpose is, on the basis that neither party had been able to provide a satisfactory explanation of the underlying overall policy. I'll take this briefly, because while it clearly is important to search for a purpose, it's not being said by anybody that it's impossible to perform the judicial function without a clear sense of the overall purpose. We touched on two cases from the 1960s under a previous iteration of the legislation which demonstrated there were problems with that. They were the Max Saga case and the Cadogan case. But in essence, in one case, where a lessee wasn't trading, allowances weren't available because there needed to be trading by the lessee, and that was thought to be, in principle, unfair. Secondly, in the Cadogan case, there was the oddity that the conclusion was reached that where allowances could be claimed depended on whether or not there was a full repairing covenant in a lease. So in that case, the party could claim allowances was somebody who held under a long lease even though he hadn't expended the money himself. I simplify greatly, but clearly there were difficulties with the old lease. And it was in the context of that that the 1971 changes came to be made. I wasn't going to take you originally to the Hansard paper because we were simply seeking to say, well, we adopt what was said by the minister as to what was going on. My friend has now shown that to you, but I stress straight away that I'm not suggesting it meets the pepper and heart test. It's there, but it's only there because we were invited to try and provide some assistance, but we're not really sure how much assistance it can ultimately provide. We can, though, say this, that under the legislation as it originally stood, Section 46 of the Finance Act 1971 was intended to be a mainstream provision, apparently intended to cover things like lifts, etc., because that's the...
Like what, sorry?
Lifts, etc., because that's the subject matter of the sort of reported cases that one had. And you see in the Stokes case, that's paradigm example of a situation where people were trying to use the Act, and obviously the difficulties, the misfiring then became apparent. So one can see from the case law at least how things have developed, and as I've mentioned, I don't need to show it to you, Melliwish in turn says, well, the changes that later came in were precisely because one needed to reverse the decision in Stokes, and one did that by the creation of the Fixtures Code. Now, the introduction of the Fixtures Code, and I think my friend accepts this and has indeed submitted it as well, did leave a shadow in the drafting of section 61.4. And if I ask you to turn within Authorities Bundle 1 to tab 9, at page 96. So if you look at the wording immediately after the tailpiece, you see, in relation to any lease entered into before 12th July 1984 and any lease entered into after 11th July 1984 pursuant to an agreement made before that date, this subsection shall have effect with the omission of the words from and, where it first occurs, which is at the end of the first line in A, to belong to him, which is after the second comma in the first line after the indent.
Sorry, where's the...
So the and is at the end of line 2 of A.
Yeah.
And the belong to him is on the first line back to the margin, about 2/3 of the way across, then if the machinery or plant would not otherwise belong to him, comma. So that's the end of the insertion. So one can see therefore what the provision said before 1984, before 1985. Now this is a slightly formalistic exercise, but that can be tied in with the introduction of the fixtures regime. If you then go to page 84, and within subsection 1, you'll see the words starting the second line, which is so installed or otherwise fixed into a building or any other description of land as to become in law part of that building or other land. So there's an exact mapping of the same phraseology. It's not that they're similar, it's the exact same phraseology.
Sorry, where are we looking at?
So section 51, subsection 1, starting at the end of the second line, my lord.
Yes, I see, thanks.
And as I say, that's confirming what one in any event gets from the Melliwish case about what was happening here. Now, the inference we say that the court can reasonably draw is that Parliament left section 61.4 in the code just in case it still covered things. But we do say that it can properly be regarded as covering things along the lines of what had been taken out and put into fixtures. To that extent, it does leave a shadow. I was wondering whether the word palimpsest assisted, and I wasn't sure it did in the end, so I'm not going to pin my colours to that mast. But we do say that may provide some assistance to this court in getting over the difficulty of, as we're just looking at it, completely shorn of context. One is able to see some context, even on the face of the 1990 Act. And of course, one is allowed to look at authorities in any event in relation to earlier legislation, regardless of it being a consolidation act. So we do say that, as it were, what can be regarded as an earlier paradigm, the sort of thing that appears in cases, so things that are done during the course of a lease by a lessee, is the type of situation, if it's found and if it doesn't fall into fixtures for some reason, that the Act was leaving in place. And I do accept on perhaps a just-in-case basis, dare I say, rather similar to the point my Lord Justice Underhill put to me earlier this morning. So, coupled with that, and on the just-in-case submission, I should also show you a comment made in the tax law rewrite project, which is Authorities tab 15. This is Authorities.
Just one moment.
My friend cavils with my word authorities. I was simply seeking to say it's in the authorities bundle.
Yes, got that.
It's authorities bundle tab 15, page 150. And it's really a couple of words in paragraph 348, which I'm putting forward as a suggestion that it's simply a question of fact. I'm not using it for any other purpose, but they're saying there, this clause is based
Sorry,
on...
again, I'm being rather slow. 50, where are we?
We're on page 150.
Yes, okay, I've got it now. 348.
348, under clause 70, plant and machinery provided by lessee. This clause is based mainly on section 61(4) and 8 of CAA 1990. It provides for the rare circumstances in which a lessee has to provide plant or machinery under the terms of a lease but does not own it. So it's that factual statement on the basis that those tasked with considering the rewrite project will have done some research, one assumes, or one can reasonably infer, and one can see from that that it appears to be the case that it's rare circumstances we're talking about. That's as much as I was going to venture on the vexed subject of the purpose of section 61(4). The next thing I was going to move to was issue 2, were the satellite launch costs expenditure on the provision of plant. And of course, for this, we're talking, to use the phrasing used by the revenue, about the freestanding ancillary expenditure, as we describe it. I can take this very briefly, because the submissions, I think, could easily end up simply as repetition of points with greater emphasis as time went by. There's very little to go on. There's no direct authority on the point. What we say is that the authority that exists assists us, and we say is also consistent with what one can imagine the legislation was seeking to try to do. We say it is artificial to split out as if they're hermetically sealed elements A and B, i.e., as my friend calls them, the expenditure condition and the belonging condition, because apart from anything else, the nature of expenditure is something that has got to be leading towards ownership in due course. There's going to be a nexus, if I can use that phrase. Now, my friend described a functional test at one point, and I think the outcome of the debate on that, certainly as we perceive it, is perhaps trying to put a label on it isn't necessarily going to assist the court enormously. The question is, well, how does the legislation work, whatever label you apply to it? We think there may be some benefit still to using the word nexus, but it's a case one has to look at both the section and also how previous courts have tried to address the language in its application to practical circumstances.
Did you accept the idea, which I think we discussed yesterday, that there's a sort of scale of possibles? You're looking at, it's a remoteness test with black and white and grey in between.
We would respectfully adopt that. So certainly remoteness can have many forms, and we do say that trying to give an absolute abstract answer isn't a solution which is likely to appeal itself to this tribunal, and it's not one that we propose. The question is, looking at facts of the situation, has there been expenditure on the provision of plants? And it can be too remote because it's the obtaining of finance, for instance, that's long in advance. But we also say it can be remote in the sense that there's no sufficient nexus with the purchasing, the ownership, if it's simply freestanding costs. So my friend used the example, for instance, that if he's asked to provide a marquee, well, it's just his job to bring the marquee, but you only have to phrase the question slightly differently to say, well, if Mr. Prosser asks one of his friends to transport the marquee there, has his friend provided the marquee? And the answer probably is no, he's transported the marquee there. Let's say Mr. Prosser says, I'll put up the marquee when it's in place. I've got a friend who can do something. He's going to bring the marquee along. Well, it might become a question of fact to be investigated, whether it's Mr. Prosser who's incurred money on this, or whether the friend has done him a favour. The friend then puts a bill in. As I say, I give the example that even to pose the simple proposition my friend put, that providing the marquee must involve the transport cost, well, it really depends on how you look at it, and what is the legislation trying to do here? My Lord Justice Underhill yesterday asked the question. I'm trying to work out situations where you get ownership through something other than buying something. Yes, I can see there are other costs there, but you've got the ownership in consequence of buying it. Well, that may carry with it some other costs, because case law says it does. But if you're taking out the actual costs of buying the very item of plant, why should it be said that in consequence of that expenditure, the transport expenditure, there's ownership? The two they're linked. We're not saying that they're the same thing and one should just muddle them up completely, but it's wrong to say that they are hermetically sealed in the way my friend seems to suggest.
I quite see, well, take it by stages. You accept that if Abbey National had incurred the launch costs, then that would have been capital expenditure on the provision of the machinery.
That's always been our case.
But can I just pause there? I don't want to interrupt my Lord's flow. But do you accept that simply because the obiter observations in the case law make it difficult for you not to, or is there a principled reason why that should be so?
They perhaps from our perspective come to the same thing, my Lord. If a matter such as this were ever to go to the highest court, I suppose that would be a question just to reconsider. But for these purposes, no, it's not. It's not ever been raised as an argument.
No, but I'm not trying to make you take a point you probably can't take and certainly don't want to take. I'm just trying to understand the conceptual basis. As you can probably detect, I'm not sure I would have said what Lord Russell or Lord Russell said. But
they are obiter remarks to that extent. There is no case directly on point, but they've been acted on for many years.
Yeah, fair enough. I'm sorry to interrupt my Lord's point, but I just wanted to get that clear.
Yes,
yep.
I think, as I say, they have been understood by the market and by those instructing me as being a correct statement.
Okay.
and it would be certainly a major change, I suspect, to take a different view in the light of the longevity of that decision.
So let me go to the other extreme. Some benefactor decides it's a good idea to fund the launch costs and does so. Plainly, there's no question of the benefactor getting a writing down allowance. But he just can't because he won't be incurring the expenditure for the purposes of his trade.
And indeed,
Or indeed potentially any trade. But he said he won't be incurring the expenditure.
There are a number of problems would arise, my lord,
Yes.
yes.
But here you have in A, without looking any further to ownership, a limiting criterion, because it has to be a person carrying on a trade incurring the capital expenditure on the provision of machinery for his trade. Now, why isn't it, if Abbey National is incurring the expenditure for the purposes of its trade, and now you have someone else incurring the expenditure for the purposes of its trade, well, why isn't that good enough?
Well, in a sense, it goes back to the question of what is A trying to do? Is it simply looking at that question to the exclusion of all else? Or is it, we would say this is more a reflection of the real world, it's asking you to look at the item which is being purchased. And we've included some submissions in relation to the Guthrie case in our written submissions. And that was the case, I don't know whether it's very short, I can turn it up. It's tab 34 in the second authorities bundle. What happened in this case, and the decision is very short, it's found at 439 to 440, was that Mr. Guthrie had paid money towards a car which had fraudulently been sold to somebody else. So the question was, could he get an initial allowance for the expenditure incurred? And the answer was yes, because he'd incurred that expenditure. Now, there was no belonging requirement at the time. But we say it's also the case that it's clear that what he was trying to do was buy something that he wanted to own. So, albeit he was able to get the allowances without showing ownership, nevertheless, he was incurring expenditure which was of the type that was moving towards ownership, i.e., it's almost implicit within what's now A that one should be considering moving towards ownership of the expenditure. So, it's, again, this is an old case. I'm not sure it entirely answers my Lord Justice Newey's point, but we say it's a pointer, just a factual scenario, to the fact that even within expenditure as a standalone, there is some sense of where it might be leading. Now, the reason why he didn't become an owner was entirely a matter of fortuity or misfortune, perhaps, because of the fraud. But we say that's a separate point. It's the fact that it was otherwise proceeding towards ownership, and the fraud revealed, if you like,
or another way of putting it, it was the purpose of the expenditure.
Yes, my lords, and I'm conscious that this is the legislation as it stood at the time, but I do say it's consistent with the point that I put, and at least provides some answer to my Lord Justice Newey's question to me.
I'm just glancing at the sideline bits. I see 440 of the bundle. And the latter part of the penultimate paragraph, the Lord President says, when, as in this case, there has been a bona fide expenditure of capital for an approved purpose. The approved purpose in the context of this statute will have been for the purposes of the trade, presumably.
I hesitate to divine precisely what he meant. He's described the different parts of the Act. I think at this stage people were very much focused on what capital allowances were trying to do. So did you fall within one of the relevant parts of the 1945 Act? And it could be that he simply means that. It otherwise falls within one of those parts. So I can't give your Lordship a definite answer.
Yeah.
So I'm not going to take you back to it, but my friend showed you the relevant passages from Ben Odico in particular. And we say that when you go back to look at the notes, the obiter statements, they are linked, we would say, in a way that suggests that transport, etc., is additional to core expenditure. And that was both in the passage of Lord Wilberforce and the passage of Lord Russell that my friend read. I don't propose to read them again unless your Lordship would like to be reminded of them. Essentially for reasons that your Lordship, Lord Justice Underhill gave, Berkeley Curl, we say, doesn't really take my friend any further, and I wasn't proposing to address that in detail. The only thing perhaps to add is that one of the curiosities of that case was, in a sense, there was an acceptance, as far as I can see from the decision, that allowances of some sort should be available, but the question was under which head of the legislation they should fall, and that's on the first page of the decision. So if they were covered by industrial building allowances, it was 3/20 you would get, and if they came under plant and machinery, it was 3/10. So maybe that was the essence, in many ways, of the underlying dispute. So we do say that if my friend's submission is correct, then section 61.4 becomes a provision which operates in wider circumstances than has hitherto been understood to operate. We're certainly unaware of anybody previously, on my instructions, having raised freestanding expenses of this sort as an argument. And my friend would perhaps say, well, that doesn't mean I'm wrong. And I accept that, but we do say, in the context of legislation which has been on foot for many years, it is at the very least an indicator. There is the question of how this fits in with the general position in the Act. My friend referred to you yesterday to parts, shares and contributions in particular, so situations where he says there can be more than one owner. As to parts and shares, well, we said that they don't cause any difficulty. There's no risk of overlapping or competing ownerships. And in relation to section 153, again, we've also touched on that. It may not go quite as far as my friend says it perhaps ought to have done, but the starting point is that sections 153 and 154 take away from the recipient, in terms of the expenditure that he can claim allowances in relation to, a sum equal to the amount contributed by the contributor. Likewise, the contributor only gets allowances for the amount they have contributed. So the legislative technique, therefore, is very different to what my friend seeks to rely on in section 61.4, which he simply says, well, freestanding, there is to be whole ownership of, in this case, the satellites, because I meet the requirements. And we haven't gone through the Stokes case in detail, but one of the points made in that, and the reason why there was the difficulty which led to the change, is that belonging as was pointed out, is predicated on there being a single owner. So exceptions to a single owner in the legislation, well, there may be certain ones provided, but in terms of the general thrust of the legislation, the starting point at the very least is not to assume there is to be multiple ownership. My friend also referred, and it was the first time he touched on it in award submissions, to section 40, subsection 5. And certainly overnight I haven't been able to get any huge wisdom on this, but it's in the context of short-term leasing arrangements that may last for a number of years, 4 years or up to 10 years. And what it does is ensure that the person said to be the owner remains the owner, notwithstanding he's perhaps transferred it to a related person or somebody else. And it does that only for the purpose of the immediately preceding subsection. It doesn't create allowances more generally. It doesn't seek to affect section 24 or the part or the Act as a whole. It simply says for the purposes of the previous section. So it's tightly confined to a particular circumstance. So we do respectfully say that that doesn't obviously take matters any great deal further. And at the risk of repetition, you already have my points that because of the complete silence in section 61.4 about the position of the actual owner, one's left with, well, how do we apportion? My friend says, well, it's X over X plus Y. If X is what I've spent on the launch, and the total combination of the launch costs and the costs of the lessor are the denominator, then you've got a calculation. And he says that's sensible. Well, but it simply doesn't say that. Finally, and this perhaps doesn't add a great deal to what I've already said, as regards freestanding expenditure, we say you can legitimately ask yourselves, is it inherently likely that what could be relatively minor installation or transportation expenditure should give rise to deemed belonging? It's not a fundamental point, but we do say it's a reasonable question to ask when assessing what the proper role of section 61.4 is. So moving to issue 3A, now this was about whether there was a requirement to provide. And my friend's oral submissions focused on the contractual documentation, and I'll do the same. The wording required under the terms of the lease, we say, is a deliberate restriction. For what it's worth, I can show you in Stokes a brief comment by Lord Justice Robert Gough on the point. Given we don't have a huge amount to go on, it is perhaps useful to look at that. That's Authorities Bundle 2, tab 43. Now, what he was seeking to do was to rebut, if that's the right word, an argument by the taxpayer that a lessee could be an owner for the purpose of the legislation, in circumstances where there was to be only one owner, namely the freehold owner. And in dealing with that, he addresses section 46.2 in passing. It's the sidelined passage at 771. If I can simply ask you to cast your eye across that. don't place a huge emphasis on it, but I do show it to you because it is a commentary that does tie in with this issue. We say that the legislation tells you there's a requirement and tells you where the location of the requirement is to be found. And it is a deliberate decision as to a restriction. So the question on this argument is whether there is an obligation, let's say a legal obligation to launch, or something that is a requirement. We say the natural meaning of that is that it's a contractual obligation of some sort, because that ties in with looking for something in the lease. In terms of what actually is to be found, my friend's shown you various provisions, but an essential feature of this case, which is unusual, plainly unusual, is that there is a deliberate provision whereby the lessee can terminate for convenience. Now, let's imagine a situation where you've got a lease of property, and that's a repairing lease. You've got a covenant to keep the property in good repair along the way. Now, if you fail to keep the property in good condition along the way, you are in breach of covenant. It's not the case that you've had a choice not to repair the property, you're simply in breach of covenant. The unusual feature here is, and I'll show you the Getsco purchase contract to identify this, is that right until the last moment, IMSO does not need to go ahead with a launch. So looking at, this is the supplementary bundle, at divider 10, page 130. And Article 28A, Inmarsat may terminate this contract in whole or in part.
Sorry, just give me one moment. Yes. Thank you.
Inmarsat may terminate this contract in whole or in part for Inmarsat's convenience at any time prior to completion. And then when one looks to the I3 novation agreement, which is in tab 11, at page 144, actually, I should go back a little bit, just to give it context. On page 142, 4.2 begins, and that's headed rights of the lessor. And then further on page 143, there's a list of rights the lessor does not have. So 3 lines in. The lessor shall have none of the following rights or benefits contained in the original purchase contract, all of which shall remain with and continue to accrue to the lessee. To the
Sorry, I haven't kept up. Where are you?
Sorry, middle of page 143, my lord.
Yeah.
So without prejudice to the limitation, etc., these will all continue to accrue to the lessee to the exclusion of the lessor, as if this agreement had never become effective. And then you look through to the following page at letter B. The right to terminate, cancel, rescind or invoke any other remedy in the purchase contract pursuant to, and basically you see there Article 28. Now, as we've said, this perhaps isn't so surprising when you understand what the context was, because originally IMSO simply had 2 procurements. It was going to procure launch services on the one hand, and it was procuring the building of the satellites on the other. Now, it is it's not just unlikely, it's simply not the case that anybody would impose an obligation on himself to complete another contract. These are simply two things you're doing. I won't try and give domestic examples. It seems to me that the point speaks for itself. So it's only when the purchase contract for the satellites gets novated that a question of whether there ought to be some sort of requirement gets put in, and a deliberate contractual decision is made, negotiating between sophisticated parties with sophisticated advisors, no doubt, and the documentation is very extensive, as your ladyship, your lordships will fully appreciate, and this court hasn't been burdened with it. But in the context of that, a decision was made not to impose what we would say is a requirement. When the upper tribunal reached a different view, we respectfully say they fell into error, and we also say that they were wrong to dismiss our reliance on the Enstone case. I'm going to try and keep my reference to that case very short. That's found at tab 24 of the first authorities bundle. And I think rather than me try and explain this straight off, if I ask you simply to read the head note down to the end of the
So sorry, what sort of tab reference?
It's the tab reference is tab 24. And I was going to ask you to read the head note down to the end of that first page, the 270 in the bundle. May also assist to look very briefly at Article 4 as well, because that will hopefully make a little bit more sense having seen the head note. It's found at 274 to 5, and again it's the sidebarred passage.
Yeah.
So my aid memoir to myself says, well, there are 4 layers here. First, who is to affect the performance characteristic of the contract? Secondly, if it's a company, identify the place of central administration, unless, thirdly, it was entered into in the course of trade, in which case the country will be the principal place of business, unless, fourthly, under the terms of the contract, the performance is to be effected somewhere else. So it comes in at that 4th stage. And the approach taken was that, well, something short of a contractual requirement isn't sufficient. One goes through to page 278 in particular.
What you ask us to read, the sideline passage then.
It's the sideline passage at, 277 to top of 278 first of all, and then we'll go to a further passage.
Sorry, which paragraphs you ask us to read? 21 and 24.
I think for current purposes, you could simply look at 24.
Okay. Yeah, well, that's really just introductory.
Yes, and then go through to 29 and 278.
Yes.
And so in particular there we draw attention to the natural force of the English wording, and we say that that has resonances for this context, and the need for a reasonably clear method of establishing something suggests looking to the terms of the contract express or implied, rather than some more vague concepts such as what the parties anticipated. May I just check with my friend on one point? My friend says I've strayed beyond the first of his three arguments in addressing Enstone. I think he's right in terms of the phrasing of my skeleton. But I'm proposing this as an answer to what he said orally yesterday as to, well, what does it mean, requirement? I'm saying that this is an indication that it's a contractual requirement. So that leads me finally to the chronological flow breaches.
Does it? Sorry.
It's a subject to your lordship.
You laid the groundwork on the required under the terms of the lease. What about the specific answers to Mr. Prosser's point? He says, well, if you look at the lease, that says you have to comply with applicable laws. The applicable laws included the convention. The convention said IMSO had to behave in certain ways. So therefore, there was a contractual obligation, forget about anything else, to launch.
I apologise. I'm taking as read my skeleton in view of timing, but we do adopt what was said by the FTT in relation to this, that generalised obligation to comply with relevant laws we say isn't, or applicable laws, isn't sufficient. And when, of course, as my lord put to my friend yesterday, when one looks at the convention, is it right to say that it includes a requirement to launch of the sort the draftsman has in mind? This is where we always circle back to, of the sort the draftsman has in mind in section 61.4. And I've given an example which you may or may not consider as relevant, but the simple example of a lease where the lessee is required to do certain things. Now, your lordship, Lord Justice Newey, yesterday expressed some scepticism about the, as it were, the position under the ongoing section 61.4, or ongoing as it was at the time of the relevant matters, namely, might it really be about display cabinets, for instance? We give that as an example, and we repeat it as an example on the basis, well, that is an envisageable situation. It might be unusual, but the lessee, during the course of the lease, has an obligation under the lease to provide something. And in that kind of paradigm situation, it's not going to be a question of trawling through many, many layers of agreements to find something which is to be inferred from a general statement in an international treaty or something made under it. It will simply say, and it's the lessee's job to replace the display cabinet halfway through the period of the lease. And at the end, either lessor will be the owner. So that may not entirely answer my lord's point, but that I hope is what we've already said in writing, perhaps further elaborated for your lordship.
Let me just ask one more thing. You've taken us to provisions contemporary with the lease agreement, I think, or at least a master lease agreement, which referred to IMSO retaining the right of termination. What is the significance of that in the context of what seems the key provision, key question, which is how do you construe what is the effect of clause 7.03 of the master lease agreement? I mean, the question is, did clause 703 of the master lease agreement, in the circumstances which happened, impose an obligation to launch? Now, when you're addressing that question, what, if any, relevance does the preservation of the right to terminate have?
Well, we say it's central to the relationship here, in that this is not a case, simply ignoring the capital allowances legislation, saying, is this a case where you would characterise IMSO as having an obligation to launch? No, they've created a situation where perhaps it's very likely in certain circumstances they will, but they've created a situation where it's up to them whether they launch or not. And there may be some...
Can that be right there? As long as the contract is on foot, they are, assuming all the other hurdles are got over, required to launch. And the fact that they have a right to terminate, which will mean that the whole contract goes, and therefore including, so if I said right to launch, I meant requirement to launch, means that the requirement to launch goes, is neither here nor there, is it? Because the question is what the contract requires them to do so long as the contract is in force. Or am I missing the point?
Well, you're putting to me, in a sense, my friend's point, that, well, the termination defeats what is otherwise an obligation. So unless and until you terminate, maybe this is a way of putting it, unless and until you terminate,
right,
there is an obligation.
Because after all, the contract could be determined lawfully for a whole number of reasons.
Well,
that wouldn't.
The curiosity, I think it goes back to this double procurement point. The curiosity is, of course, it is set up that for convenience, it's not that there doesn't have to be a reason. For convenience, they can choose not to go ahead.
A footnote point, it says until completion. Completion for these purposes is the passing of title and is therefore the firing of the ignition on the first stage. Is that right?
That's my understanding.
Yeah, no, fine. I just wanted to check that. Yeah.
Just as to that, I think this is a complete red herring, which I've introduced. But reading the first tier again, it referred to title passing, is it on launch? But at any rate, it has some further potential fallback, the expiry of a guarantee or something.
I would have to remind myself, I don't think those papers are before the court. So there could be delivery for storage as well. So there are in the midst of the complex provisions other alternatives, but the essential position is that it's launching of the...
Yes, I'm sorry. It's just I wanted to make sure what completion meant in this context, but that doesn't address the point that I was putting to you, and I see what your response is.
My lord, yes, it's, as I say, I've tried to strip back and say let's ignore the capital allowances legislation, and you were asking yourself, well, is IMSO required to launch? It's perhaps a characterisation point. Do you say there's an obligation, or do you say, well, the fact that IMSO's got this choice which is, if you like, personified by this right to terminate whenever it suits, that there's no obligation, well, no requirement, I should say. You then, having reached that view, you then try and put this into the legislation and saying, well, is this meeting what the legislation had in mind? And I don't want to spend too long over it, because in a sense that's a simple question for this court rather than elaborate submissions from me.
I mean, if you go back 2 stages, back from the legislation, back from the right to terminate, the core question in a way is, could Abbey National have sued if there had been no launch?
If IMSO has terminated for convenience, they can sue.
They would assume the contract's still in place. So assume the lease is still in place. Would Abbey National have been entitled to complain of breach of contract if IMSO had not launched?
I hesitate to hypothesize, because in the context where there are such clear provisions, complicated documentation, well-advised parties, it's very difficult to imagine that arising. But yes, if there has been no termination notice and IMSO has just chosen not to do something, failed to do something that it should have done, then it's going to be in breach.
So to be clear, is it implicit in that you accept that absent a termination, it was contractually obliged to launch?
Well, subject to the question of how you then characterise the nature of the contract overall, in terms of the narrow contractual question, they will be launching, they will be required to launch, if you want to use that phrase.
There isn't, I don't think, a timetable for launch, is there?
So I'm being reminded of something. I'm being corrected. I don't have, I think, anything like the amount of full documentation. I think the position is that it's up to IMSO to identify when there should be a launch. So if it doesn't, then there's no right in Abbey National to sue. And if it goes on for a certain lengthy period, then there's an unwinding contractually of the position, which has financial consequences. So on that basis, Abbey National can't force, certainly the view expressed by my learned junior, that can't force that IMSO launch.
That's quite an important point, isn't it?
I can, I think, try and find some part of the documentation to assist. I'm not sure we've got everything before the Court of Appeal.
I mean, speaking entirely for myself, I slightly feel that if that point were to be entertained seriously, we would need to see that that was what the contractual documentation showed.
Can I leave it this way? We'll see what we can produce over the short adjournment, if there is something. If there's not, we're in your Lordship's hands as to whether the matter needs to be pursued further. But as I say, I'm uncomfortable suggesting that there's everything to be found in the bundles you've got. I think that
No, I rather suspect that it isn't there. I think let's regroup. But if you are taking this point, which my immediate reaction is, if it's right, is quite important, then I think we, as my lord said, we've got to see chapter and verse, and Mr. Prosser will have to have an opportunity to come back on it.
my lord.
But that could be done if necessary in paper submissions, depending how complex it is. If in the end you think it's not right, or is involves so much argument that it's not worth a candle given your other points, then that's your choice. But at the moment we'll treat the point as not taken until you come back to us after lunch and say it is taken.
My lord, appreciate it.
Don't go too much on my saying it looks like an important point. That's my first impression, but I may be wrong.
My lord, my lady, I was going to move on very briefly to the chronological flow point. The freebie issue, the chronological flow, is a very short one ultimately. It's to some degree going to be coloured by the view you take of what the role of section 61.4 is, and whether it is, for instance, things along the lines of things that happened, like the display cabinet example I've given, or whether it's got a much more open texture, the type my friend suggests. We say the natural situation where the legislation applies is the replacement of something during the course of a lease. That's just the use of the language. We say that the draftsperson in section 61.8 has reflected that as well, and we say it's not clear why this subsection would have been necessary at all if it doesn't have the meaning that HMRC contend. So we say that it focuses on replacement during a term of something, but seeks to extend that to a situation where, for whatever reason, there is not a lease in place, but one can see subsequently that the term has begun. And we don't therefore agree with my friend when he says, well, as long as a lease has begun is what it means. We say that's just not the natural meaning of the words. And for reasons given in writing, we say that there is no assistance to be gained from section 61, subsection 1, which is seeking to do something different. Now that's the position of a lessor who is constructing plant and machinery with a view to leasing it. And there is a different use of tense, as you'll recall, in section 61.1 to section 61.4, and we say the use of the present tense in section 61.4 is an indicator, further pointer, that it's concerned with things that happen when a lease is on foot. That's the paradigm. That's all I wanted to say on that. It's a point you've got the submissions, but beyond that, I don't think it really benefits from any greater further elaboration. So, subject to returning at 2 o'clock with any further points I have on the nitty-gritty of the contract, we say that my friend Inmarsat, with great ingenuity, sought to rely on two very little used provisions of the legislation in novel ways to reach a result which the legislation did not have in contemplation, and we say the appeal should be dismissed.
Thank you very much indeed, Mr. Gibbon. Yes, Mr. Prosser.
Can I start then with section 78.1?
Yes.
And Mr. Gibbon gave two examples of when he says section 78.1 can operate, does operate. One was the one that's mentioned in 78.2, which is the the death of the trader and then the passing of machinery or plant to a beneficiary. That would obviously be a gift. And so I make the point again that there's no obvious function for section 78.1.
Sorry, I'm being slow.
Yeah.
I'm sure you're right. Why would it obviously be a gift?
Well, because you've got a deceased trader and a beneficiary under a will or an intestacy who is a donee of the, it's not a sale, he's described as a beneficiary under the will or the intestacy of the deceased person. That looks like, being a beneficiary, that he's not a sort of a contracting party in any way.
Yeah, no, I see it once now you spell it out. I was just wondering whether that was what gift in section 81 covers. You'd say, why not?
Why not? A gift inter vivos or by will or on intestacy, in my submission, would be covered either way.
Yes, I see.
So it's difficult to see what difference, apart from section 78.2 itself. I take that point, that 78.2 is doing something, but in terms of what 78.1 is covering and making a difference about, that first point I would submit is not so obvious in relation to that case. And then the other example that was given was to do with a bankrupt. And I think I misunderstood what Mr. Gibbon was going to say yesterday. I think and he'll correct me if I've got this wrong, that he accepts that on the moment of the trustee in bankruptcy being appointed, the trustee doesn't then automatically succeed to the trade of the bankrupt. That the trustee may, and he's got power to carry on the trade of the bankrupt, and from the time that the trustee does so, clearly he's not acting as an agent in any way for the bankrupt. It would be the other way round insofar as the bankrupt is doing anything. He would be acting on behalf of the trustee. What until then? So just to follow up that point, my understanding, and I confess I'm not an expert in this area, but my understanding, looking at the legislation yesterday and overnight, is that on the appointment of the trustee, first of all, the estate of the bankrupt vests in the trustee. That means all the property of the bankrupt at that time. There's an exclusion for tools of the trade. They don't necessarily pass. But as to what happens after the bankruptcy, there's nothing in the legislation that, subject to the trustee exercising his power to take over the trade, there's nothing in the legislation that forbids the bankrupt from continuing to trade. And because, let's imagine, for example, the trader in question being someone who's providing a service. Maybe he's making door keys, in a shop making keys, and as also a repairer of shoes or something like that. So he's got the tools of his trade, and he provides services still as people come in the shop. The money that those customers give the trader, my understanding is after acquired property. And because that wasn't property of the bankrupt at the time of the appointment of the trustee, it doesn't vest automatically in the trustee. There are provisions whereby the trustee can claim after acquired property, and there are also provisions to do with income payment orders, which would require the bankrupt to hand over money that he's received in those circumstances. But the basic point is the mere appointment of the trustee is not of itself a succession, first of all.
I'm just trying to think this through. You're obviously quite right. if an individual who carries on a trade, a tradesman, becomes bankrupt, he can clearly continue to provide services as a plumber or whatever, and then if the trustee is to attach the income, it has to be as after acquired property. Suppose it weren't quite like that, and the bankrupt had carried on a business that had goodwill attached to it, and then questions arose as to passing off, say. How does it work then?
Well, insofar as we're looking at property which is part of the estate of the bankrupt at the time of the appointment of the trustee, clearly that does vest in the trustee. And therefore it would be a question of the trustee enforcing whatever rights there may be. If it's a question of passing off as against the bankrupt rather than by the bankrupt, then it would be a case of the trustee defending that claim, as it were, with the benefit of the rights that the trustee has got that are vested in the trustee.
I'm just wondering how far, and I haven't worked this out, I'm wondering how far you can distinguish the bankrupt's right to carry on providing his services from the goodwill attached to the business, which would carry with it potentially intellectual property rights, which you would have thought would have passed to the trustee.
Well, could I put my answer this way? I'm not sure what the answer to that is, but the mere fact of raising those sorts of points means one couldn't say, as a blanket proposition, that the case of someone becoming insolvent is an example of where Section 78(1) will apply, in the sense that there will be a succession. There may be a succession to the trade. It all depends on whether or not and that's accepted by Mr. Gibbon. There may or may not.
Isn't that all Mr. Gibbon needs?
Well, except that, let's suppose that we're not looking at the personal tools of the trade, which is sort of an exception for an individual sole trader who's got his physical tools. In the fact that the way that the legislation works is that the assets of the trader pass immediately, whereas succession may or may not occur until later, raises the question, what is the nature of the assumption which HMRC say Section 78(1) is making? We know that HMRC say that this isn't a condition. They say it's not a condition, it's an assumption about ownership. But what's the nature of this assumption? In particular, what relationship must there be, or is there assumed to be, between the succession on the one hand and the actual passing of property on the other? Now, before the upper tribunal, and the upper tribunal record this in their decision, that HMRC's case was that the passing of property, the actual passing of property, results from the succession. Now that's one way of putting it, but if you ask, is that the case with an insolvency, then very likely the answer would be no, because the passing of property will have happened on day one, when the trustee is appointed, and the succession may only occur at a later date. Now, therefore, is it the case that there doesn't have to be that timing relationship, that the succession happens and at the same time or later the property is transferred? The point I'm trying to make is that this is an assumption which HMRC say the legislation is making, which in my submission is a very vague and uncertain assumption. We know, and I think HMRC aren't suggesting, that it's an assumption along the lines of Section 77(4), which says immediately before the succession it must belong to the predecessor, and immediately afterwards it must belong to the successor. It's not a strict assumption along those lines. I don't think HMRC say it's that sort of assumption. But if you say, well, it's not along those lines, then what is the relationship between them in terms of timing and causality? Is it enough that the transfer of the property occurs before, but within a reasonable time before, or afterwards in a reasonable time afterwards? What is a reasonable time? What is the limitation, if any, between the passing of property and the succession? And my submission is that it's highly unlikely that Section 78.1 will be drafted upon a completely unstated, vague and uncertain assumption along those lines. That isn't the way that the legislation operates. And the insolvency example which HMRC have given is a good example of how, although they say that's an example of Section 78.1 applying, it's not a case where the property passes as a result of the succession. Elsewhere in their skeleton, HMRC say that the property must pass in the context of the succession. So they've been quite careful in not being specific, as it were. But what is meant by in the context of? Does one imply that wording into Section 78.1 and say, well, as long as I say, there's some connection in some way between them, that's good enough? That silence on the part of 78.1 in my submission suggests that that assumption simply isn't there. HMRC say, well, 78.1 is all about a valuation mechanism. I would submit that that might be a conclusion one reaches as a result of the various points that have been raised, but shouldn't be regarded as the sort of starting point. Otherwise, that really begs the question, because obviously the very issue is it a mere valuation mechanism or not? But one can't say HMRC are right because it's a valuation mechanism. I accept that in Section 26, which is to do with disposal value, that obviously is a valuation mechanism. But it doesn't follow that Section 78.1 is as well.
I don't think it's quite fair to Mr. Gibbon to suggest that's how he put it. He explained why he thought it was, why he submitted it was a valuation mechanism.
Well, I mean, have I got this right? You say HMRC have said that this is about the position of the predecessor, and that's completely wrong. But you don't, do you, quarrel with the idea that 78.1 would have a role in relation to valuation for the successor?
No, I submit that it definitely does have a role, and its only role is in relation to the successor.
No, I quite follow that, but it would have a sensible valuation role, whoever is right, because it would have a sensible valuation role in relation to the successor, even if it didn't have one in relation to the predecessor.
I accept that it has a sensible role to play in relation to the successor, whoever
Regardless
is
of
right
who is
about
right.
the actual property passing.
Yes.
And my submission is that it has no sensible role to play at all in relation to the predecessor. And the thrust of the deemed sale, divided into parts A and B, indicates that it's not a mere valuation mechanism. I mean, if I can put it this way, it doesn't say that on the occasion of the succession, the successor shall be deemed to have incurred capital expenditure equal to market value. It goes further than that and deems there to be a sale to the successor, and my submission is that that goes further than simply telling you that he's incurred some expenditure. It's B that tells you what expenditure he's incurred, but A tells you that there's a sale. think Mr. Gibbon accepts that the words at the end, by virtue of this subsection, allowances by virtue of this subsection, means that it is because of this subsection that allowances are available. I'm not sure whether he does accept that, but in any event, my submission is that those words indicate that allowances are available which otherwise wouldn't have been available, or at the very least might not have been available. Mr. Gibbon suggests that perhaps this is to do with manipulation, ensuring that the successor cannot, by some nefarious transaction, get allowances more than should be given to him. But that language, allowances made by virtue of this subsection, doesn't suggest that it's restricting the allowances that the successor can get. It's giving him allowances which otherwise he would or might not have got at all. But that, I would submit, is more than simply a valuation mechanism. It's simply saying how much. It is telling you that allowances are being given that otherwise wouldn't be. Perhaps because the successor is not incurring any expenditure at all, in fact.
Are you coming to a fresh point?
That would be a good place to stop.
Yeah. Any, doesn't perhaps really matter, but any feel how much longer you're likely to be, subject obviously to any point of the kind Mr. Gibbon has reserved?
Well, subject to that, 40 minutes.
Very well. We'll meet again at 2 and see whether Mr. Gibbon does have anything more for us.